Good morning. About Juvenile Justice Act. You know, the Juvenile Justice Act deals with the children. What all are the other provisions which deals with the child involvement in crime? The Indian Penal Code have some slab of age. Up to 12 years, if the child commits any crime, no offense. From 12 to 14, the mental status of the child should be ascertained whether the child is having such a mind to commit crime. Thereafter, from 14 to thereafter up to 18 years, they are considered as a minor. Then adolescent, from 19 to 21, adolescent. All these provisions were considered initially under 360 CRPC admonition. Thereafter, Probation of Offenders Act. Then the Juvenile Justice Act has been introduced. So these children's offences were considered as juvenile delinquents. The Juvenile Justice Act now, as on the Juvenile Justice Act, 2000 Act have three part of duties. Number one, taking care of the children. Number two, about the wandering children and taking care of the children. Then if they commit any crime, they are called as delinquent. Their delinquents will be dealt according to procedure. Then third one was adoption. It also deals with the adoption of the orphan children. So that all those things you should give. Here, a case wherein a hardened criminal at the average age between juvenile age as well as adolescent age seems to have gone up to Supreme Court. This judgment deals with the various aspects how to determine the age. AR 2022 Supreme Court 1060. Number one. The plea of juvenility has to be raised in a bona fide and truthful manner. No matriculation or equivalent certificate submitted. Instead, he relied on date of birth issued by school first attender. School record found unreliable, procured only to support plea of juvenility. Then another aspect, they say, juvenile in conflict with law, determination of age, reliability of birth certificate. Birth certificate found to be registered subsequent to filing of application claiming juvenility. Then there seems to be some procedure in Haryana that the rules permit registration of family register. How to register the family register by a VAO and Gram Sabha, head of the Gram Sabha. And there is also a procedure to register the children born from scheduled caste community. To what extent that disparity shown, probably for obtaining community certificate, etc. maybe. Then the question arises about ossification test. How for ossification test means growth of bones, growth of teeth, and the formation of joints. This all the development of hair, pubic hair, these all are the doctors can give some opinion, but the superior multi-number of judgments says this ossification test is subject to variation after 2 years, lesser or higher. So finally, the Supreme Court did not accept the journality of the accused, and he was directed to be treated. Then the medical board has to decide it. See, they say you go through the every aspect of the judgment. Textbook of medical jurisprudence by Modi, height and weight, ossification of bones, that has been discussed. So many area was discussed. It will be very helpful if you go through this entire judgment, not only for this Juvenile Justice Act procedures, you can for POSCO Act and for nowadays rape cases and marriage, love affairs cases, all these it will help the child did not went to school or there is no birth certificate for the children. Then this area where the which they say appellant was born at house, such birth had to be reported to registrar by head of household or by nearest. Birth certificate many years after birth and not immediately or within prescribed time cannot be relied to determine the claim of juvenility. Here the rules says how far this rule to be followed. Whether such rule is prevailing, family it is described at paragraph 23 of the judgment. Under section 110 of the UP Panchayat Raj Act 1947, the rules were framed to register the birth of the children by Gaon Sabha. Gaon means village. Gaon Sabha. So that has to also be, that is there at paragraph 23. You can also go through that so that you can understand. Then finally, Section 35 Evidence Act has been discussed in the judgment. It says the register maintained in the ordinary course of business by a public servant in discharge of his official duty or by any other person in purpose of duties specially enjoined by the law of the country in which such register is kept would be relevant fact. So here this village register is a relevant fact, we could be proved. That is subject to appreciation of the evidence, that's what they say. So family 6A of the family register rules were discussed. So you have to understand the sections 35's importance, how to bring that. Thereafter you see 79 of Evidence Act also we discussed. So they discuss at paragraph 34, they discussed right from the beginning of 74 of the evidence. It discussed with the public document. Public document did not mean that it is a government document. It's for the purpose of public. If it is some records are maintained, it is public document. Then section 77 says certified copy of is admissible. That is our 77. 79 presumption. Section 79 presumption of this document. In the absence of any evidence to prove that it was incorrect, its correctness is liable to be presumed. Section 79. So all these things may help you definitely to understand the various aspects. So do not leave this judgment, go through again and again, keep it on a file or table anytime, so that unless and until you are at home with the Indian Evidence Act, sometimes only you can come across the relevant provisions which is being adopted while pronouncing judgments, like in which case Manu alias Vishal Chaudhary versus State of Haryana, AR 2022, Supreme Court 1060. Hemant Gupta and V. Ramasubramaniam, both have been. Hemant Gupta seems to have given this judgment. Manoj alias Monu alias Vishal Chaudhary versus State of Haryana. So very important. Apart from appreciation of evidence, that is up to you. Do ignore that. You ignore the result of the judgment also. But you should keep the judgment on your file and record so that whenever you want to challenge any document, challenge any birth certificate, challenge the ossification test, you can refer these cases. So that best wishes.